Hello, good morning, afternoon, or night. We are Group 7, and we are gonna be discussing Riley versus California, by Andrea Gomez, Leslie Martinez, and Damaris Ovalle. Okay, for the summary of facts, we have that in 2009, David Riley was pulled over for expired registration tax. He was arrested for driving with a suspended license, and then police found guns in his car, took his phone, and searched it without a warrant. And then they discovered photos and message linking him to a gun in a shooting. Riley argued that violated his Fourth Amendment rights. The case eventually went to the U.S. Supreme Court. And then for the parties involved, we had the petitioner, which was David Leon Riley, that he argued the phone search was unconstitutional. And then for the responder, we have the state of California, since they used the phone evidence against him. And then for the judgment, we have that the Supreme Court ruled 9 versus 0 and in favor of Riley. And then police must get a warrant before searching a phone, even after an arrest. There are some exceptions, which is like true emergencies, such as immediate threats or danger. And then we also add a video that it's 3-minute video for the very understanding of the case as well. The next slide is going to be presented by Andrea.
Okay, hello, my name is Andrea Gomez. I have the issue and the holding for this group project. The main legal question that was presented to the court in Riley v. California was whether or not it was constitutional to search the digital information on a cell phone from an individual who had been arrested with or without a warrant. Although Riley v. California did not violate the First Amendment's right to freedom of speech, it did address and assert the Fourth Amendment's right to privacy, in which police may not search the phone of a person who has been arrested. Whether they were arrested legally, it doesn't matter. It is unconstitutional for the police to search the digital cell phone on a person that was arrested. In Riley v. California, the main question was whether law enforcement could search digital data on a cell phone taken during an arrest without a warrant under the Fourth Amendment's prohibition against unreasonable searches and seizures. In the holding, yes, the court did rule that it was unconstitutional. Like I said in the previous slide, that it is unconstitutional for police to go through the phone of a person who has been arrested. The court decided in a unanimous vote of 9-0 in Riley v. California, in which the police typically cannot search a person's cell phone without a warrant, even if they are lawfully arrested. In Riley v. California, Chief Justice John G. Roberts Jr. delivered the unanimous majority ruling, and in a separate opinion, Justice Samuel Alito expressed partial concurrence with the verdict. Thank you so much too for your time. My name again is Andrea Gomez, and that's the end of my presentation. Thank you.
Hi, my name is Damaris Ovalle, and I'm going over the opinion and the national impact on Riley versus California. So, the Supreme Court ended up ruling that the search of a cell phone without a warrant violates the Fourth Amendment due to the right of privacy. Cell phones do hold a lot more information regarding privacy, and they ruled on limitations for searching on devices such as simply getting a warrant if you really need to search a device. The reasoning behind their unanimous decision was that the regulations for a search incident to arrest do not apply to digital data. Um, the Chief Justice, actually, Chief Justice Roberts, um, did state this quote above that digital data stored on a cell phone cannot be used as a weapon or to harm an officer to um, officiate the arrestees, I'm sorry, arrest. So, with that being said, um, they tried to use a different case in this. I'm sorry. Um, in this case, being the United States versus Robinson. and the court ended up dismissing it because it was related to physical options objects, and digital content on cell phones is much more sensitive as it involves personal information. And with that being said, the court didn't end up overturning Robinson, but they did establish a modified percent, and the court agreed that on regulations on the searches of the digital devices should be reviewed. And as it said in the second quote in bold, um, we therefore decide to extend Robinson to searches of data on cell phones as and they hold more instead that the officers must generally secure a warrant before conducting a search. So basically, their whole opinion revolved on securing a warrant instead of just searching the cell phone. So in the national impact, this case actually impacted the United States in many ways, as you could see. The court recognized that digital devices do carry more private information, unlike physical objects. They cell phones go more in depth. So privacy is a concern when it comes to smart devices, and warrants are not required to go through any digital device after this case. And as the quote says above, on June 25, 2014, and perhaps most privacy ruling of digital ages, the court unanimously held that law enforcement officers in general are not permitted to search cell phones incident to arrest without a warrant. So basically, the whole thing is that warrants are now required for going through digital devices no matter what. Thank you.